Hey, we're gonna watch Colin. We're gonna find Colin. Watch Colin. He's in your front left. I'll make the screen a little bit bigger. But yeah, let's hang out and just keep Simpson going today and watch for Colin.
What I will do is I will grant the defendant's motion, reinstate her previous bond, but that reinstatement of her previous bond will not take effect until 12:01 a.m. on 8/8/2025, since she already has the tether on.
So, Your Honor, I'm just, if that means that she'll be held through 12:01 a.m. tomorrow, correct?
Correct. She
did.
can then get herself somehow down to Ann Arbor by 8 if she's going to attend that session.
Okay. That would be a little more difficult. We'll try to make that happen.
It shouldn't be difficult. She can walk to Ann Arbor by that time.
Thank you, Your Honor.
I know you could, and you're much older than she is.
Well, not at present, but thank you.
Okay. All right. Thank you. No. Well, no, because I'm reinstating the tether. So we may need a new just tether order. So that they're clear. But she already has it on. Court calls the case People versus James Belleville.
On behalf of the people.
Good morning, Your Honor. Edward Drukas on behalf of James Belleville, who should be appearing on Zoom. Could you unmute Mr. Belleville?
Yeah, I'm unmuted.
Okay, state your name, sir.
James Michael Belleville.
All right, go ahead.
Thank you, Your Honor. I'm asking for about a 3-week adjournment pursuant to what's in our green sheet.
Probable cause conference, August 28, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls the case of the People versus Sheena Stout.
Assistant Public Defender Chelsea Virgils with and on behalf of Sheena Stout.
Your name, ma'am?
Sheena F. Stout.
All right, what are we doing?
Your Honor, we are asking for an adjournment in this case. I'm also asking to briefly address bond.
We have a green sheet. Probable cause conference in this case will be adjourned to August 28, 2025, 9 a.m. Yes, as to bond.
Your Honor, Ms. Stout expressed to me desire to seek substance abuse treatment. I believe that the prosecution may stipulate to that. I can have a stipend order presented to the court later today. So we're just asking for the court to allow her release to inpatient treatment.
I will always allow release to inpatient treatment. Just send me the order. I'll sign off on it.
Okay, thank you, Your Honor.
Bond will continue. Thank you. Court calls the case People versus Taylor Adams.
And I'm on behalf of Mr. Adams, who is to my right. Please state your name for the record.
Taylor Adams. I have a question, Your Honor, if that's okay.
You have a question?
For you, if that's okay.
For me?
Yes. What are my charges on this case?
Yeah. What are they?
What are they? Yeah.
You don't recall them from arraignment or?
No, I just wanted to make sure. I was told that it was malicious. It's not attempted. And I want to make sure that it's attempted. That's what I was charged with was,
okay.
Legend.
You have two charges.
Yep.
That allege that on or about December 6, 2024, location of Sibley Road in Sylvan Township. Count 1 is attempted malicious of malicious destruction of fire or police property.
Attempted.
That's the 2-year offense.
Yep.
Then the second charge is reckless use of a firearm or weapon. That's a 90-day, $500 fine. Those are the 2 charges of that.
Already attempted. Thank you, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter.
Without objection, probable cause conference, August 28th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thanks, sir.
Those people. Court does call the case of the people versus Adonis Sweat.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Adonis Sweat.
Adonis Sweat.
Okay. You would like the same adjournment to the 11th?
Yes, Judge, the prosecutor just informed me that there's more that he was made aware of yesterday, more discovery.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. The court does. Court does call the case of people versus Trayvon Addison.
Madam Mayor, on behalf of Mr. Addison, who is approaching, please state your name for the record.
Trayvon Addison.
Your Honor, we request to set this matter for preliminary examination and all discovery is complete, as far as you're aware.
People have their witnesses available on the 19th.
Thank you.
Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge.
12 noon with you.
12 noon, that's before me. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case people versus Shaquille O'Neal Tubbs.
Good morning. I'm Rob Jekyll on behalf of Mr. Tubbs. Judge, in this matter,
State your name, please.
I'm sorry.
Shaquille O'Neal Tubbs.
Thank you.
This is Judge, Mr. Ken O'Rourke from the PD office has him in recovery court. I talked to Ms. Sample. She says if we can waive him up to circuit court, he will be eligible for the recovery court.
Okay.
Is that your signature and X? Okay. There's a waiver, Judge, properly signed,
I've
but
seen Mr. Tubbs for I don't know how long. I'll tell you if it's his. Yep, that's it. Sir, you're waiving your right to a preliminary examination.
Yes, sir.
You understand a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
All right, people also waive their right. Preliminary examination haven't been waived, defendants bound over on the single count.
as far as the information, Judge will waive its reading. My client would stand mute.
Defendant able to waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 21st at 1:30 with Judge Slade.
August 21st, 2025, 1:30 before Judge Slay.
We'll probably be in recovery court.
Oh,
Yes.
Well, I don't know.
Oh, okay, hold on. We're gonna go to, gotta go over, get to recovery court.
Okay.
Okay? All right, thanks.
Bond will continue. Good luck, Mr. Tubbs. Court calls case People versus Seth Anderson.
Good morning again, Your Honor. Assistant Under Dottie Lieb on behalf of Mr. Anderson, who is approaching. Mr. Anderson, can you state your name, sir?
Seth Anderson.
And Your Honor, today we're going to be requesting an adjournment. We've discussed a potential offer to the prosecutor. They've indicated that they'd need some more time to decide on that, and my client's indicated he'd like some time to consider that as well.
August 28, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Sean Belledew.
Edward Drix on behalf of Sean Belledew.
Name, sir? I have before me two plea forms. Is that what we're doing today?
Yes, Your Honor.
They both indicate that in each case he'll be pleading to an added count two of larceny, 200 to 1,000. He'll be pleading no contest. Needs the 1 year offenses. Upon a successful plea to that charge, count one would be dismissed. There is no other agreement.
That's our understanding.
The court's full understanding. Is that the people's understanding?
That's correct.
May I have him sworn?
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so you got it. Lower your hand and then state your name.
Sean Lauren Belledew.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to, or no contest to two charges of larceny, 200 to 1,000. Those are misdemeanors, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is subject matter to theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in these cases, and you would be sentenced before Judge.
Yes, Your Honor.
Before Judge Valvo and Perry. Which one's Valvo? Do you understand what a no contest plea is, sir?
Yes, sir.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand these
Yes.
charges?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. So, sir, to the charge of larceny 200 to 1,000 contained in the case ending in 5670. He's already signed sentencing judge waivers. I don't need them.
Yes, Your Honor.
Just trying to get the offense date on this. I have my file. Get these files this way. In 5670 occurring on July 10th, 2024. How do you plead?
No contest.
To that same charge contained in the case 5615 occurring. Crazy. I'm sorry, sir. I don't know why they have this file done in this way.
Thank you.
Really? Where's my complaint? You have an offense back. June 5th. Occurring on June 5th, 2025. How do you plead?
No contest, Your Honor. Contest?
You understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form in each of these cases?
Yes.
Do you have any questions regarding any of those rights?
No, Your Honor.
Look on the podium, you'll see a copy of one. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Nope.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And because, well, I won't ask that part. The court has been provided and has reviewed in the case ending 5670, University of Michigan Department of Public Safety report for their case number 2490305419. And in the other matter, Ann Arbor Police Department report for their case number 2431255. Any objection to the court having reviewed those reports?
No, Your Honor. No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel? Well, before I do that, sir, I do have to advise you that if between the time of my acceptance of your plea and your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea. I would also need to advise you that any sentence agreement, evaluation, or recommendation, the court would no longer be bound by. You understand that?
Yes, sir.
You do?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, it's a no contest plea for civil liability. I don't think.
Thank you. Okay. All right. I did not ask.
Yes, Your Honor. People are satisfied.
Defense is now satisfied.
Court will accept the defendant's no contest pleas to count 2 in both of these cases. Count 1 is dismissed. You're going to get 2 sentencing dates, and you're going to have to reconcile them. Pre-sentence investigation and reports are ordered at 15th District Court. In case 5670, sentencing will occur
August 26th at 9 a.m.
August 26, 2025, 9 a.m. before Judge Valvo. In the other matter, sentencing will occur
August 28th at 8:30 a.m.
August 28th, 2025, 8:30 a.m. That is before Judge Perry. Bond in each of these cases will continue.
Thank you, Your Honor.
I don't know why he can have those back. I don't need the extra paper.
Thank you.
You all right? You okay? Court calls the case People versus Anitha Barnes.
Maybe we're just different people.
Anitha Barnes.
Can't find a feaster when you need it. Really, you sat here all morning. I called your case and you weren't here. What are you?
I had to go. It's the apple, Judge.
What?
Sorry, Judge. I wanted to test my breakfast. My apologies.
Seriously?
I apologize, Judge. I don't know.
Go ahead. Ma'am, could you please state your name? Because
Anitha Barnes.
thank you. Because
Thank you, Judge.
features are mad. Anyway.
You should have a green sheet in your
I
file,
do.
Your Honor. Ms. Barnes and I were unable to connect. I know we're trying to get this matter resolved. Hopefully she'll be able to give us a call before the next pretrial date, PCC date, and we can hopefully get this matter moved forward.
Probable cause conference, August 28, 2025, 9 a.m. Bond will continue. All right. Thank you, Ms. Barnes.
Thank you, Judge. Sorry again.
No. Enjoy that apple.
I'll wait for my apple.
No, go. Please eat it. There's nothing like looking at a half-eaten apple that like makes my day just go forward. Go ahead, finish. Go ahead and finish your breakfast.
I'll be right there.
All right. We know where to find you. Court calls the case People versus Savannah Crittenden. Crittenden.
Good morning, Your Honor. James Fifelski, standing in for Attorney Robert Ellman on behalf of Ms. Crittenden.
Andrew Childers, attorney on behalf of the people.
Ma'am, you have any objection to Mr. Fifelski standing in for your counsel of record?
I don't, Your Honor.
All right, very good. What are we doing?
Your Honor, we are asking the court to set this for a preliminary examination.
Discovery, to your knowledge, is complete.
Yes, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Roderick Gates.
For Douglas for the people?
Serious? I don't.
Brother Judge,
You didn't even finish the apple.
I'm working on it.
What?
There's like 4 more bites taken out of it.
Smile.
Working on it.
You got like small teeth or something.
I
You
do.
should have been done with that, right? Shanaz?
You're supposed to chew
You know,
like,
he should have been done.
isn't it like 20 times for each bite or something?
I don't
Take
know.
some time.
I don't know how to eat that apple, but it's still here.
Torshell Feaster, assistant public defender, on behalf of, but apparently not with, Mr. Bates. We did try to reach out to Mr. Bates by email and by phone. We did not receive any response. For the record, I would request an adjournment, but I have no idea where Mr. Bates is.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you.
I'll try to get it.
Yeah, go finish. That's a joke. Let's call it Feaster. No.
Did he just make a Colin joke?
People versus Ryan Carter Price.
If you were to the people.
And Assistant Public Defender, Shanaz carry out. Your Honor, on behalf of Mr. Ryan Carter Price, who's approaching. Mr. Carter Price, state your name for the record, please.
Ryan Carter Price.
Mr. Carter Price, state your name for the record, please.
Ryan Carter Price.
Thank you.
Judge, we're asking that this matter be set for preliminary examination.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025. Time. 12 noon, that is before me.
They just had a good zoom on him for a second.
Bond will continue. Thank you. Court does call the case of People versus April Black.
Stephanie Cannon on behalf of Ms. Black.
Oh, wow. Where have you been? Where have you been? That's my way of saying I missed you. Not really. Don't get all sappy. We just missed you because it was quiet.
I've been good, Your Honor.
Okay.
Well, trying. Your Honor, we're just asking for a brief adjournment in this matter. I have mitigation information we're hoping to use to resolve this short of trial.
Probable cause conference will be adjourned August 28, 2025, 9 a.m. Bond continue. Thank you, ma'am.
Thank you so much, Your Honor. And I'll find this picture.
Court calls case People versus Jay Dingman.
Assistant Public Defender Chelsea Virgils with and on behalf of Jay Dingman who approaches. Mr. Dingman, please state your name.
Jay Dingman.
Can you sign this for referral to treatment court? Your Honor, we're asking for an adjournment today for referral to mental health treatment court and ask the court to sign the referral form. I would also ask to address bond when appropriate.
Of course you would. we know how long they're operating before they do anything and make their assessment?
I don't know, Your Honor. In my experience, it's been a couple weeks, but I don't know for sure.
Yeah, okay, well, let's at least give it a shot so you can just sit there out. Pardon? 3 weeks. Okay. I'll then adjourn this out to August 28th, 2025, 9 a.m. as to bond.
Your Honor, we are asking you to consider a personal bond today. He does have a permanent address in Ypsilanti. He has the support of CMH, who he's been working with long-term, as well as his family. He asks to await his decision about treatment court out of custody, if you would consider that.
All right. Response from people?
Your Honor, we do not think that would, that's for Mr. Dickman. He did fail to appear at his last court date. Note that the reason we believe that his health court may be appropriate for Mr. Dingman is because he does struggle with mental health issues. He has been with for a term, but we know that despite that, he still has picked up this case, which we're using the description has a lot to do with his health status. So, Your Honor, we do not think that Mr. Dingman on his own is able to appear when required to do so. So I think that if he was just released, we wouldn't see him until we don't know what time. So, Your Honor, I would object to release on a personal bond unless it was with a covenant to inpatient treatment.
Right, but there's not been a request for inpatient treatment. Certainly, I would consider that if that were what was being asked, but I don't think that's what's being asked of the court. The motion for bond modification and/or reduction is denied. The defendant already has a record of failing to appear before the court. His bond will continue as set. Thank you.
Thank you, Your Honor.
Court does call the case People versus Daniel Bowe.
People.
Good morning, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Bowe. Mr. Bowe, can you please state your name for the record?
Daniel Bowe.
All right, he keeps appearing on the screen in the upper left. I can't zoom in on it, but he's black shirt, silver or white tie.
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading no contest to the charge of retail fraud in second degree, the 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. There is also the agreement of restitution in, well, it says the amount of no dollars.
That's correct, Your Honor. There's no restitution necessary for this case.
So why is it on here? Anyway, never mind. All right. Hey, have him sworn.
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so you got?
Yes, ma'am.
Lower your hand and then state.
Daniel Bowe, DANIEL
All right. Sir, it is this court's understanding you're going to plead guilty to, or plead no contest to the charge retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property stolen. If that's greater than $2,000, that would be the maximum fine. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Correct.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
And you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty. Or no contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
You almost blew it.
No.
All right. You don't have any.
I don't get to sleep at night. I got a newborn at home, so my mind's everywhere.
You got a newborn at home?
Yes, sir. Yeah.
Okay, we'll get to that. Is that your first one?
No, it's my second. My other one's 15.
Then that's old school for you then. All right. You signed an advice of rights form. No questions regarding those rights?
Correct, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
Yes.
But he was not at the time.
Well, no.
Not at the time of the offense.
No.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily?
Correct.
Of your own free will?
Yes, sir.
And because you believe that you are, well, I won't ask you if you prove that you're guilty. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 249721. Any objection to the court having reviewed that report?
No objection, Your Honor.
Court, upon a review of that report, does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I do accept your plea, and if between the time of this acceptance of the plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation if there were any in this case or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Correct, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None from defense, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
October 6th at 9 a.m.
October 6, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Congratulations, young man. Boy or girl?
Boy.
Boy?
Yeah, he just don't sleep at night. He's an angel during the day, but when it comes to nighttime,
that's how you got in trouble. So the apple doesn't fall far from the tree. All right. You take care, young man.
Thank you, Your Honor.
Court calls the case, People versus Cedric Green.
Ready, Judge?
Wow.
Court shall please the Assistant Public Defender on behalf of Mr. Green. Mr. Green, please state your name for the record.
Good morning, Cedric Green. Thank you. No apple?
I finished.
Did you finish?
I did finish it.
Took you long enough. All right.
Slow eater. Sorry.
What are you doing?
Mr. Green has asked that I set this matter for preliminary examination. I believe all discovery is complete.
Or people have their witnesses available the 19th.
Yes, sir.
Preliminary examination in this matter will be set August 19th, 2025. Set at 9
a.m.
9 a.m. before Judge Moore.
Thank you very much, Judge.
Bond continued. Thank you. Court does call the case of the People versus Zaria Brand.
Bailey Zend on behalf of the people, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with on behalf of Zaria. I'm sorry, Zaria Brand.
Your name, ma'am?
Zaria Brand.
Zaria.
Your Honor, we do have a resolution. There's one outstanding issue that I just asked Ms. Zenda about a few minutes ago. So we have the paperwork, but we're going to look into that one issue. So I am asking for a brief adjournment. I think 2 weeks would be correct.
Probable cause conference August 19th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Khalil Haddon.
Assistant Public Defender Alexis Zerps with and on behalf of Mr. Haddon, who's approaching. Can you state your name for the record, Mr. Haddon?
Kahil Jabron Haddon.
Thank you.
Your Honor, we're requesting an adjournment for some further discussions.
Requesting an adjournment.
Yes, Your Honor.
Probable Probable cause conference without objection, August 19th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Jamie Burke.
If you were to move the first people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Jamie Burke. Jamie, can you please state your name for the judge?
Of course. Good morning, Your Honor. Jamie Burke here.
Thank you.
Of course.
Your Honor, we're going to be requesting an adjournment, please, to satisfy the restitution amount. And
how long is that going to take him?
The longer, the better, Your Honor, but I'll leave it up to your discretion. Maybe.
Currently, I'm doing Uber, word of mouth Uber, and
okay.
And then doing trades with electronics to like pawn shops and things like that, buying them from. So I'm getting money slowly, and I just applied to a hotel this morning as well. So
we'll take a month, Your Honor, if you could.
If I can. So I can at least get the funds up, if I may, Your Honor.
Is he going to be able to do it in a month?
Absolutely.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued. Thank you.
Thank you very much, Your Honor. I really appreciate that.
You're welcome.
I hope you have a wonderful day.
You do the same.
Thank you.
Court calls the case People versus, is it Jervapko Hitana? Ms. Willingbring, I guess was the prosecutor.
Advisor, on behalf of the examiner, sorry.
Oh, okay.
Assistant Public Defender Chelsea Virgil is with and on behalf of Zdravko Kitanov. Can you state your name?
Yes, Stratford Kitsanov.
All right.
Your Honor, today my client would like to waive his right to a, I'm sorry, can you sign right here? His right to a preliminary exam.
Discussed it with that lower nail as the first enter that plea agreement, we would not be remanding for
So you're waiving your right to a preliminary examination?
Yes, Your Honor.
Is that what you're doing, sir?
The plea agreement is on the table, I believe, still.
Yes. That's what she said that.
Okay.
Then, yes, Your Honor.
Plea agreement to obviously some felony charges that would take place in circuit court.
Yes.
So to accomplish that, are you waiving your right to a preliminary examination?
Yes, I'd like to take the plea agreement.
Pardon? Okay. Well, I have to make sure that you understand that a preliminary examination is a proceeding where the people would have to show by a standard of probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, Your Honor.
All right. My understanding is that you're waiving or giving up that right to have that hearing and proceeding to circuit court for further resolution, which may include a plea agreement.
Yes, Your Honor.
All right. Is that your understanding?
Yes, my goal is to take the plea agreement. So, yes.
All right. But you understand you'll not have a preliminary examination. I just want to be clear on that.
I understand.
All right. The people have indicated they also waived their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Your turn.
But I cannot be taken.
We would acknowledge receipt. I'm sorry. I was momentarily distracted. I apologize, Your Honor. We would acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea as to all counts. Pretrial in this matter will be set for
August 26th at 1:30 with Judge Kunke.
August 26, 2025, 1:30, Judge Kunke.
Thank you, Your Honor. If I may approach to sign the following information.
Yes, we'll bring that over to you. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Bradley Chavez.
Andrew Childers appearing on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Bradley Chavez, who should be appearing by Zoom. Bradley, can you please state your name for the judge?
Bradley Chavez.
I have before me a plea form. Is that what we're doing?
That's correct, Your Honor.
The plea form indicates that the defendant will be pleading guilty to an added count to use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also no objection to seeking 7411. That's the court's full understanding of the agreement.
That's correct.
That is correct, Your Honor. Thank you.
All right. Chavez, could you please raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. State your name again for the record.
My name is Bradley Chavez.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do.
All right. You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You understand that you're waiving those rights as well as all the rights on that form?
Yes, I understand.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
Yes, I am.
All right. Were you on probation at the time of this offense?
Yes, I was on probation during the time of the offense, and I was actually, this was brought up in that court case. So I did have to turn myself in and serve time for that offense for violating. That was back in December, so that court is aware of that violation, and I did do time for that.
Okay, well, thank you for all of that information. I do also have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, Your Honor.
And you still wish to plead guilty to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of July 26, 2024, at the location of State Street near Dewey, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was methamphetamine?
Yes, Your Honor.
Counsel, sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing in this matter, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence recommendation or evaluation the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thank you.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea of guilt?
People are satisfied.
Defense is satisfied as well, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be September 12, 2025, 8:30 before Judge Perry. Bond continues.
Thanks, Your Honor.
Thank you.
Do I have to check? My bad. I was gonna say, do I just have to check in with the 15th District Probation Department now?
Yes, sir.
Okay, all right, that's all I want to know. Thank you, Your Honor.
Thank you. Have a good day.
You too.
Court calls case People versus Kristen Knight.
That goes for the people.
Stephanie Can on behalf of Mr. Knight, who is approaching. Mr. Knight, when you are at the left turn, please state your name.
Christian Knight.
Thank you.
And Your Honor, at this time, we are going to ask for a preliminary exam.
All discovery is complete.
Yes, Your Honor, to my knowledge.
And would the people have their witnesses available the 19th?
Your Honor, we will do our best.
Preliminary examination in person, August 19th, 2025. 9 a.m. That is before, is it 9 a.m.? 12 noon, that's before me.
Thank you so much, Your Honor.
Thank you. Bond continue.
Oh.
Court calls case People versus Deshaun Clifton.
That goes for the people.
And Stephanie Can on behalf of Mr. Clifton, who is approaching, Your Honor. State your name, Mr. Clifton.
Sean Clifton.
And Your Honor, we are negotiating on this. We've been back and forth. We're just asking for some additional time to see if we can reach a resolution short of a preliminary exam.
August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Derek Coleman.
Alexander, on behalf of the people, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Coleman, who's approaching.
Your name, sir?
Derek Coleman.
Thank you.
Your Honor, we respectfully request that this be set for preliminary exam.
Discovery is complete.
To my knowledge, yes.
Preliminary examination in person will be set August 19th, 2025. That's 9 a.m. before Judge Moore. People would have their witnesses available. I should. All right. Thank you. Bond will continue.
Thank you, Your Honor.
Court does call the cases of the People versus Jacqueline Murray.
Andrew Childress, appearing on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Miss Jacqueline Murray. Jacqueline, can you state your name for the judge when you're ready?
Jacqueline Murray.
Okay. What are we doing?
Your Honor, there should be a plea form, 2 of them in there. We have a resolution.
Yes.
What would be the 15th District Court files?
Yes.
Based on the court's acceptance of on those, the people would file an ollie cross on the 14th.
Thank you. All right. Very good. All right. And they are both, the defendant's going to be pleading to count, well, in the case ending in 5597, it would be count 3 of use of fentanyl, with counts 1 and 2 being dismissed. And in the other matter, it would be count 2 of use of fentanyl, with count 1 being dismissed, as well as the case ending in 622. Both of those 1 years. That's the court's full understanding of the.
Perfect, Your Honor.
That's correct.
May I have her sworn?
You solemnly swear or affirm the testimony you're about to give
whole truth and nothing but the truth, so you got.
Yes.
Lower your, say your name.
Jacqueline Murray.
All right. Ms. Murray, it's this court's understanding that you're going to plead to 2 charges of use of fentanyl. Those are misdemeanors punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo and Judge Perry, respectively, in the 15th District Court. You understand that? All right. And understanding that, you still wish to plead to these charges?
Yes, Your Honor.
All right. So to the charge of use of fentanyl contained in the case ending 5597 with an offense date of June 22nd, 2023, how do you plead?
Guilty.
To that same charge contained in the case ending in 5540 with an offense date of October 6, 2022. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yep. Yes.
and because you believe that you are indeed guilty of this offense, of these
Yeah.
offenses.
Yes, Your Honor.
Starting first with the case ending in 5597. Ma'am, on the date of June 22nd, 2023, at the location of Warden Avenue near Dexter Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes.
All right. Going to the next one. On the date of October 6, 2022, at the location of 727 Miller Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes, Your Honor.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea, as well as any sentence agreement or evaluation the court would not be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any promises, threats, or other inducements which have led to this plea?
None on the
None on the defense, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Defense is satisfied, Your Honor. Thank you.
All right. In the case ending in 5597, court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. I'll just finish up on that case. A pre-sentence investigation and report is ordered at 50 District Court. Sentencing in that case will be
August 28th at 8:30 with Judge Perry.
August 28, 2025, 8:30 before Judge Perry. Bond in that case will continue. In the other matter, the court will, it said so, accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15 District Court probation. Sentencing in that case will be
August 26th at 9 a.m. with Judge Valvo.
August 26, 2025, 9 a.m. before Judge Valvo. Bond in that case will continue. And the case ending in 25 or case ending or in 0622 as referenced on the plea form, that case is dismissed. Thank you. Thank you. Court calls case, People versus Jermaine Dalton.
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Dobby Leba on behalf of Mr. Dalton. Dalton, could you state your name, sir?
Jermaine Dalton.
And Your Honor, we're requesting an adjournment today. Mr. Dalton indicated to me he'd like to seek private counsel.
You what?
He would like to seek private counsel.
And pants.
Oh, I'm sorry, Your Honor. Do apologize.
I believe he'll be seeking both.
How much time does he need to do that?
How much time do you need, sir?
Honestly, could I have 3 weeks?
Your Honor, would the court be willing to do 30 days in this matter?
The only time I'll grant an adjournment for these purposes for you to seek private counsel, private cause conference will be adjourned September 4th.
Thank you, Your Honor. Thank you, Your Honor.
2025, 9 a.m. Bond continued.
Thank you.
Do you have a green sheet?
Yes, Your Honor. Oh, apologies. I have it in my hand.
Case People versus LaDonta Skinner.
Assistant Public Defender Dobby Leba for Mr. Skinner. Mr. Skinner, could you state your name, sir?
LaDonta Skinner.
Hey, what are we doing?
We're going to be requesting an adjournment in order to receive some additional discovery as well as look into some additional matters.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Curtis Damon.
Apologies, Your Honor. Lord Yagis, Public Defender, on behalf, but not with Mr. Damon, Your Honor, may I, or may we approach?
Yes.
Sorry.
Yes. Yeah, on this one.
Yes.
Right. Okay, bench warrant will issue for defendant's failure to appear. This matter. Court will indicate that given all of the circumstances in this case, I'm going to set no bond. Get him here. See what we can do. That warrant will issue immediately. Okay. Thank you. Court does call the case People versus Anthony Turner.
Deputy People. Stephanie Cannon on behalf of Mr. Turner. Please report your name.
Anthony Turner. All right. Turner, it's this court's understanding that he is going to plead to an added count 2, guilty of attempted unlawful use of a motor vehicle.
Yes, Your Honor, that's my understanding. That's correct.
That's a 1-year offense. Well, I don't understand this form. Why do I have 2 penalties and 2 charges?
Your Honor, I'm sorry, go ahead. The count comes with the mandatory notice that the sentencing court could opt to sentence him to a 90-day offense, but we can't actually have a plea under that. It's just the sentencing notice, and we're required to listen.
The statute was amended, I think, last year.
No, I got what the statute is. I'm just, the way this is laid out here is this. Okay. All right. So you're going to plead to attempted motor vehicle unlawful use. That is a misdemeanor punishable by up to 1 year incarceration or $750 fine plus court costs. And that's an attempt. Do you understand that, sir?
Yes.
The court could also sentence you to a 90-day sentence or a $500 fine for plus court costs. You understand that?
Yes.
And you understand, sir, that upon your successful plea to that charge, count 1 would be dismissed.
Yes.
All right. I haven't had him sworn in. Let's have him sworn.
You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Lower your hand and then say your name.
Anthony Turner.
All right. And sir, you do understand what I indicated in terms of what you're going to be pleading to in the maximum penalties?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
I understand.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of the trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
April 2nd, 2024, at the location of 508 Pearl Street, City of Ypsilanti, Washtenaw County, State of Michigan. What'd you try to do or do regarding a Jeep Wrangler that makes you think that you're guilty?
Well, it was parked in my driveway the night before and the doors were open. The keys were on the seat and I just took off with it the next morning. It was left there overnight and I took off with it the next morning.
You were gonna bring it back though, correct?
Yeah, I was. It was at my residence and it was just parked in my driveway. I had every intention on bringing the
So the doors were open, keys were in it. You just took off for a ride. You were gonna bring it back.
Yeah, well, I have a condition, and I just thought that like a moment without strenuous exercise would be like sufficient enough for myself. I have glass in my esophagus.
Got it. Okay.
And I wanted to go and get breakfast.
Oh, okay. So now I see. So you were attempting to leave, but you were going to bring it back. Did you bring it back?
Yes, sir, I did.
Okay. But you didn't have permission of the owner of that vehicle or the person who had proper custody of the vehicle to use that vehicle?
No.
All right. All right. I think I got everything. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, that if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation or evaluation. You understand that, sir?
I understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor, I wouldn't consider it that, but he is being admitted to the mental health treatment court, so I guess I would just add that for the record.
He's being what?
Admitted to the mental health treatment court.
And I believe the court has the paperwork on that as well, Your Honor.
Is that part of this agreement?
It's not really part of the agreement, but I just.
Your Honor, we did that outside of that. He actually asked me about mental health court, and like the second time I visited with him. So he was already referred and put into it by the time the plea. So I don't believe the plea is contingent on it, but he is voluntarily participating in mental health court.
Got it. Okay. All right, very good. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
The people are satisfied.
You have, Your Honor.
The court will accept the defendant's plea to count 2, count 1 is dismissed.
Your Honor, can we address bond?
Sure.
Your Honor, my client has actually done at least 1 or 2 of the mental health court sessions already. Is that correct, Mr. Turner?
Yes.
He is asking to be released. He has the paperwork regarding who he needs to contact in mental health court. Can he be released prior to sentencing?
Is this the only thing holding him?
Yes, Your Honor.
Any response from the people?
The court's discretion.
You don't have a distinction between in custody and out custody dates, or you just have one.
No, I haven't.
You got it.
Gotta come back. Pre-sentence investigation and report is ordered. I will. Bond will be reduced. $5,000 personal recognizance bond with other conditions remaining in effect. So an out-of-sentence custody date would be sentencing date.
August 27th at 10 a.m.
August 27th, 2025, 10 a.m. before Judge Barr. All right, Mr. Turner?
Yes, sir.
Taking a chance on you, better show up.
I got you, man.
You got it?
I got you.
Okay. If you don't show up, I got to come out and find you myself.
All right.
You don't want me rolling up on you, do you?
No, sir.
All right, you're good. All right, take care. Court calls the case, People versus Cartier Drains.
Lori Yaki, Assistant Public Defender. Your Honor, may we approach?
Really?
Yes, Your Honor.
Come on. Why?
Well, we see Colin. Figure out fill in this break right here. I am multitasking. These last... I've got nothing to say. That dude is making me itch. My dog got fleas a few weeks ago, and luckily we were on a road trip. So she didn't bring him back in. We caught him before we got all the way back home. But that was a freaking nightmare. Oh, I'm like literally scratching. Oh, there he is again. And then I had to clean out my truck like 5 times because I was paranoid. Where's my chat? Yeah, they brought him back though. Yeah, do you guys remember those old wooden back scratchers? I've got like 4 of them, and I just went to go get one, and now I dropped it somewhere. I can't find it. Just watching this guy. Okay, we back? Try to keep myself small so we can be on Colin Watch.
All right. The defendant is not here. We've had a bench conference case. I had, so that the record is clear, I specifically directed that this individual appear in person. Counsel indicates to me that she's been in contact with him. He, for whatever reason, can't find a ride. Maybe should have thought about that before he started acting the way he did. But notwithstanding that, I'll issue the bench warrant. Bond is set in the amount of $25,000 cash surety. I will not issue that warrant until the 14th of August.
Thank you, Your Honor.
Ms. Douglas she was telling me about how to take care of hair. She was, she was explaining. So that I don't have any, but I knew. Court calls the case, People versus Johnny Walker.
Brian Bowling on behalf of Mr. Walker, Your Honor.
Julie Walker.
All right. Judge, I'm asking for an adjournment. We need some discovery in this matter, specifically video, which I think we should hopefully have before the next PCC. And then I was just hoping to address a bond when you're ready.
Right. Well, we kind of addressed it yesterday. And he has permission to leave. Because this is a veterans treatment type of program.
That's my understanding, Judge. Correct.
Yeah. Oh, that's right. Okay. So here's our problem. I agreed to that yesterday so that he could get out in treatment. It sounded like a good program for him out in California. Problem is that when I signed the order in that case, the jail then informed me he has 3 FOC holds out of Muskegon.
There was an email sent this morning. Did you see that email? That Muskegon said they were not coming to get him on the FOC, and it was an advise and release. I know
you have that?
Court staff was, I can approach if you'd like me to. I can pull it up on my phone.
Because the last indication we got was that they verbally told us Muskegon was coming to get him.
Fair enough. Ms. Perrine forwarded the email to me this morning, Your Honor. I believe the court had been CC'd on it, so I didn't print out a copy, but
that's okay. Here's my position. I don't have a problem signing off for him to go. My position hasn't changed on it. The problem was going to be that he wouldn't have gone to California for treatment. He would have gone to Muskegon.
Yeah, and that doesn't seem to be.
People have been lost there for years. No, I'm kidding.
That's summary.
Muskegon's agreed.
That's correct. Now, on
So they're unable to pick him up. Okay, so they won't come down and get you. Is this is virtually identical order to the other one?
Yeah, my order was the snippet order I submitted this morning, Judge, was just, he has a personal bond already in the felony case. So it was just to give him the ability to leave the state of Michigan.
Leave the state, got it. Okay, just in order consistent with that, got it. Okay, that's fantastic on that. Then what I'll do, I'll adjourn this. Remind me, Mr. Walker, remind my staff as to what we adjourned your other case to.
September.
The specific date.
I can't remember specific date.
Was 17, right? Because we were going to let you get out there. Hopefully you could get on Zoom and then we could continue on with the proceedings. Now I remember. So why don't I just put this the date after? I'll adjourn this to the 18th. 9 a.m. bond will allocate
time. Okay. Yeah. That's gonna be 6 a.m. Chicago.
His fiance is in here.
She was, Judge.
Was she?
Earlier, yeah.
She waited all day yesterday for her to get out. She must like you or something. I don't know.
Thank you.
You're welcome. Court calls case People versus Dustin Duncan.
And Laura Yagi, Assistant Public Defender with and on behalf of Mr. Duncan. Mr. Duncan, can you unmute yourself and say your name for the court?
There you go. Dustin Duncan. And why is she hollow, Michigan?
She needed to be able to hear you better. Why is she out? She's writing down every word you say.
But see, it's
Right,
like,
Kristen?
why, you look at together.
That's. Are you trying to text him?
I am. Sorry, Your Honor. I know he was there.
Yeah.
I apologize.
No, you don't.
I do.
No, you don't care.
I do.
You don't care that my day has now come to a screeching halt.
I know. I do actually.
And it's usually Miss Akinroli that the case does that. But
today
now you're following in her footsteps.
I know. Your Honor, I was going to request an adjourn. Oh, and he's there. I was going to.
I had faith that he'd appear.
Thank you, Your Honor. I did too, even though my voice didn't show it.
Mr. Duncan, can you state your name, please?
Dustin Duncan.
Thank you.
Your Honor, I am, this is the first PCC. I'm requesting a brief adjournment. Mr. Duncan, I'll follow up with you. I talked with the prosecutor this morning about your options, so I'll follow up with you about what you want the next step to be in your case, okay?
Okay.
All right. So what I'll do is I'll adjourn this to August 28th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Mr. Duncan.
Thank you, Your Honor.
Court does call the case of the People versus Jeffrey Williams.
All this.
Matthew Nassar, Assistant Public Defender, with and on behalf of Mr. Jeffrey Williams. Jeffrey, can you please state your name for the judge?
Jeffrey Williams. Thank you, sir.
Yes, sir.
You're requesting an adjournment.
Yes, please, Your Honor.
Can I just bind off, sir? Could you just bind off me? See what they do to it? Cause I don't want to be wasting time just sitting here. And I know.
I'm sorry, Your Honor. I'm sorry, I didn't want to interrupt the conversation, but is he any closer to getting to treatment? Or I'll sign the stipulation.
Okay.
I'm currently waiting to get to the assessment for drug treatment court, and that's the first thing they're going to do for me before the drug treatment court is serious treatment.
Okay. All right. And I would just say that Mr. Williams has been appearing before me for some period of time over the years. He needs treatment.
Yes, Your Honor. Yes.
He actually has been through treatment, and I'll say this on his behalf. When he kind of gets through it and he's up, he's good. Just when he slips back into that bad world, then things start going haywire for you, right?
Yes, sir.
We're hopeful history doesn't repeat itself. We can move forward.
Yeah, well, I hope so too. So this is 14B. Do we have a time frame as to how they're?
Your Honor, I made a request to the council that since I think Mr. Williams does not yet have an inpatient bed, waiting for him that he contact, and I can as well contact Mr. Reyes and ask you to do that interview with the jail ASAP before he even goes out to a bed so that it can be done quickly.
Thank you.
So let's do this. I just August 28th, 2025, 9 a.m. I just don't want to put it out too far.
Thank you.
Track of it. So we'll go out to that date. And then let's see where we can get. All right.
Thank you, Your Honor.
All right, Mr. Williams, take care. Court does call the case People versus Thomas Ellis.
And Assistant Public Defender, Janelle Carrier, Your Honor, on behalf of Mr. Thomas Ellis. Mr. Ellis, state your name for the record.
Thomas Ellis.
Judge, I do have a green sheet. We're requesting an adjournment in this matter. There's some information that I just provided to the people today, so I think 2 weeks should be fine, Your Honor.
How long?
2 weeks, I think, should be fine.
Just come back and ask for more adjournment. That's how you are.
I know. I'm
All right.
sorry, Judge. I'll do better.
No, you won't. August 28th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
You're gonna promise me I'll do better, but I know that, Benny. Gotcha. Court does call the case People versus Keon Ford.
Court, when you are present, please state your name for the court.
Keon Ford. Thank you, sir.
And we are asking for an adjournment of this matter, Your Honor. I've been in touch with the prosecutor regarding my questions and concerns, and he's going to work with me to hopefully get it resolved.
Try to resolve.
Yes.
All right, let's set you out to September 4th, 2025, 9 a.m. Bond continued.
Thank you.
All right.
I'll call you like I did before. Thank you so much, Your Honor.
Court does call the case People versus Marcus Jones.
For the judge, Andrew Childers, appearing on behalf of you. Portia Feaster, Assistant Public Defender, on behalf of Mr. Marcus Jones. Mr. Jones, please state your name for the record.
Marcus Jones.
Thank you, Judge. I did have a chance to talk to Mr. Jones and Mr. Childers about this briefly. Mr. Jones had a few more questions about the plea offer in this file. If we could go out just a week or two, I think we have a resolution.
Probable cause conference, then August 28th, 2025, 9 a.m.
Can I say something?
Can you say something? Sure.
Y'all need a cell phone. Do y'all have a cell phone? Because I was just calling and calling and calling this morning because I knew I was going to be late. But like trying to get in touch with y'all was like trying to get in touch with somebody that don't want to be found by their mama.
Just call me.
But like,
Who are you telling? I need a cell phone?
Somebody need a phone.
3.
Somebody need a phone.
I just don't give you the number.
But then, man, dog, I thought I
see, you're like that child mama don't want to find.
Man, bro, I had to turn into a track star this morning. You ever seen Peter Parker when he was running for the bus? Yeah, man. Yeah.
That was you this morning?
That was me this morning, bro, with the bag in my hand and everything.
Yeah, was that down Washington?
Huh?
Were you coming down Washington at some point?
That was me.
That was you?
That was me.
Oh.
That was me.
You were going fast.
Yep.
I'll give you my number, okay?
All
All
right.
right, so here's what I think. I am not giving you my cell phone number.
Hey, I'm
just letting you know.
You're a judge. I will want it.
Yeah, you're right.
Yeah, I'm
Wanna
just
call
there.
me.
I defend myself.
So I think, let's see, who will answer? Give it, Mansoor, give him your number.
Yeah, that's a good idea. That's a good idea.
I'm sure Mr. Feaster will find a number for you.
I will.
Okay?
Yeah.
But I'm just so happy you got here.
Hopefully it is 773-9311.
What's that?
Oh, hey, she got it. So no, I'm messing with you, bro.
Okay. That's beautiful that you and Cannon shared that moment.
I didn't get it.
I didn't either. There's no telling.
All right, you have a nice day.
Okay, you do the same. Take care.
Thank you, Judge.
Man, you weren't even giving up your phone number. What? Well, I'm gonna let the powers that be know he wouldn't cover his client. Just time was just looking for somebody to call. I'm just gonna say. You know, when he said, "Can I say something?" I was just hoping I thought it would be just something. Didn't know it was gonna be all that. Court calls the case People versus Zion Jones.
Good afternoon, everybody. Ready, Judge, Torshio Feaster, Assistant Public Defender on behalf of Mr. Zion Jones, who is not present, but I know where he is. If I may.
Hey, you want to share that with the rest of us?
Yes, Judge. I got a text message from our office this morning.
If he's on a bus, I don't want to hear.
Not on a bus.
All right.
So apparently he bonded out of jail yesterday, went to work. He works on the line and he injured his leg. He's at St. Joe's Hospital. So we asked him to get proof of his hospital visit, and we're asking for a brief adjournment so he can come next week or the week after, whenever the court's pleasure is. But he's at the hospital.
So he got out of jail, went to work, hurt his leg, and now at the hospital.
Yes, Judge.
Ms. Zender, why'd you wave your head like? Wow.
And I called him to verify. He answered. I said, "I'm at the hospital. I'm getting a letter. I'll bring it when I leave." So.
Request a 48-hour bench warrant for defense failure to appear. I would just like to.
Why would we do that?
To give him time.
He has a whole story.
I will take Mr. Feaster at his word. I trust.
Okay, then.
I would also just represent, similar to the co-defendant, I am preparing an amended complaint with the added count of assault with intent to commit robbery while armed.
This was the one that you're trying to up the bond on, and
That is correct, Your Honor.
Feaster?
So, Judge, I would ask that the court not up his bond until that's actually filed.
I'm not gonna up his bond at this time, because I need the amended complaint. I don't have that. But.
And I will forward the court and the cook the hospital letter as soon as I receive it this afternoon, Your Honor.
August 14th, I'm 1 week.
Thank you, Judge.
I'll adjourn it out based on that story you gave me.
Thank you so much. And I will get the proof.
And if he doesn't show up,
I understand.
I'm gonna issue a bench warrant and take you in.
No, I don't understand that.
No, that's the way it works.
I will.
You want me to go with the story? That's how it's
You
gonna
know
work.
what? You can issue the bench warrant today then, Judge. I don't want my freedom tied to his. Thank you, Judge.
You're welcome. Court calls the case People versus Olin Thurman.
Haley Zen on behalf of the people, Your Honor. Assistant Public Defender Alexis Zerbs on behalf of Mr. Thurman, who's approaching. Can you please state your name for the record?
Olin Thurman.
Your Honor, can you briefly approach?
Fine.
They are approaching. Oh, I couldn't do it. I couldn't sit in court all day just to sit in court. I think last time I had jury duty, I fell asleep. I didn't get picked. And that was only the morning. Oh, are they back? Nope, they're not back. Yeah, last time I had jury duty, it was for a murder trial. And I kept falling asleep. But in fairness, it was like 2 months after my son was born, so I wasn't sleeping anyway. But to stay there for, I think yesterday's docket was almost 12. Yesterday's court minus, if you include all the breaks, was like 12 hours. Do you think Colin will be there the whole day? I bet he will. Where's my chat? Oh yeah, and if you watch my stream from yesterday, my system crashed. So I caught the beginning of the slap happy part at the very end of Simpsons docket, but then it got cut off, and then I think it is no longer available. I hate when they get rid of it the very next, or as soon as court ends, or within something like 6 to 12 hours. Let's see, there's a few courts that keep their recordings open for a couple days. All right, we need a Itchy McScratchy replacement just to keep us entertained. Colin even looks like he's bored. So today's a Magoo day, right? And God, I feel like there's something else. Oh, I'm still scratching from that guy. I feel like there's something else. Alex, I know you looked at part of the docket just to see what Duncan had. Or, well, maybe you just looked up Duncan. See if somebody can find the docket. But then again, sometimes we get good surprises. I am not getting a lot done at work today. Let's check my emails. Whoops. I'm supposed to be in a meeting right now. Oh, okay. I can go to it later. Oh, what's going on in the world today? Okay, Magoo. Oh, 2 cases for hearing today. Yeah, so yesterday's docket had 200. And today's PCC day, so or was yesterday no, today's PCC day. Yeah, I know. So they were having some computer, or they were having issues yesterday, so I know they took some cases from yesterday and put them on today and tomorrow. So I've got a feeling Simpson is just going to be real busy until the weekend hits. Seems like, I forgot, what court is it? 36? Is it 36D? 14? Oh, I mix up all the numbers. Here, I bet I can get you to post. Hold on. I don't know what I'm getting into by doing this, Alex, but I'm going to do it. Okay, now see if you can post. You have control over my channel right now, just so you know. To some degree. Let's see what's going on in Colin's Discord. Oh, okay, cool. The docket link from Alex coming through. So, if anybody joins, you know what? Let me see if I can put that. I don't even know what it looks like from your end. Alright. Sweet. I think that's Alex, I think you're my first mod too. I was gonna give it to Sly and Jedi the other day, but then it wouldn't work. Okay, are we back? Intermission? Everybody standing. Okay. Break time? Okay, there's Colin. Oh, go back. Wait, I'll make the screen. There's Sly. Okay, here, I'll make the screen bigger again so we can see Colin. I mean, I'm not cutting him off anyway. Okay, let's fix the screen. Let's make me disappear. Okay, I'm still here though. And there's still no sound. As soon as they... Oh, okay. Oh, there he is. Oh, that was a good Colin shot. And A and B walk out. The prosecution team is talking. Simpson's out of the room. Oh, I would not be a good commentator. Oh, we got symbols. Dang it. Maybe I gotta put myself back there. These streams usually get cut in 2 or 3 sometimes. So what I'm gonna do is, if this ends a portion of his docket, then I'm going to open up a new stream. Let me see if I can. Alright. It's still live. I think. Yeah, it's still live. Okay. It's probably a bathroom break. Wixom is baby blue? Is that Wixom? Alright. They might get a good Colin shot here, so... I mean, it's still going to be the same cutoff point, but... Oh, you could... Okay. Oh, man, I wish I could zoom in there. You know, nobody ever really looks like... Who do you think... Oh, I'm talking to Colin. Man, I need my Afrin. Okay, we've got a detective in the back. Yeah, this just looks like a bathroom break. Ooh, you know what? I realize I've got like 3 computers going. I can set up the second half of the docket. Well, they'll have a lunch break. Uh-oh. Oh. So I think that whole crew in Colin's row is with, well, are those 2 ladies with Colin? Ah, I found my Afrin. See that guy's pink shoes? Those look like they look like big shoes. Like shoes you would not want to go running in. Man, I wish they had sound here. Is that the defense attorney that has the lisp? I'm not sure. Oh, okay. I mean, they definitely look like they're all sitting together, so I assume all 4 of them are part of the same road trip crew. Hey, Wixom has a channel, doesn't he? Snow. Oh, they're all coming back in. Mole and hole. No, you did not miss anything. They're kind of in a... I think they're on a bathroom break right now, but you missed the guy that was super itchy scratchy. Guy that was on the YouTube... Oh, here, let me pop in here real quick. Guy that was on the camera that kept scratching himself for at least 20 minutes. And then that was pretty anticlimactic. Oh, the God. That's one of those words I have a hard time saying. Let's see. You missed Alex becoming a moderator. You got Colin's crew sitting right up in the front. They're cutting off Colin right now. And I've got this screen smushed, so it's not like I'm cutting anybody off. It's just narrow. And then you got big pink shoes in the back. But we haven't missed any fun court. We had a guy that was kind of funny. No Magoos yet. No sovereign citizens. Really not a whole lot of court drama. Okay. Let's kick me out. But we believe the guy in the blue shirt is Wixom. One of the, I'm assuming the lady next to him is his wife. I don't even know what. Put a chatter in timeout. Oh, you put a chatter in timeout. Yeah. Well, luckily that's luckily that's an easy one to recover from. We can always just throw a message saying sorry. Yeah, just the itchy guy. Okay, people are coming back in. Where's the? If you guys watched it yesterday, let's see if the McDonald's lawyer comes back. He was pretty funny. Man, I am pretty congested today. Yeah, Colin is bottom left, front row. Black shirt. I think it's a blue tie. I think it's a light blue tie. It might be white or silver, but I think it's blue. Man, I really think he needs a blazer, because if you look at all the people, all the lawyers, all the judicial officials, they're wearing a neutral shirt with the suit. Not to knock on Colin, but that looks more like he's ready for prom. But I don't know. I'm one of those guys that's worked a suit and tie job most of his career, and I don't really want to go back to it. I wish I could zoom. Let me see if I can zoom right now, because I think we're going to be on this camera view for a minute. No. Where's my mouse? Did I lose? Where's my mouse? Uh-oh. Okay, I'm just not going to mess with it. Oh, jeez. I can't find my mouse, y'all. Okay. What if I push? Oh, God. I'm worried which button I could push to crash the stream. Okay, I know where the mouse is at least. I just can't see it. Okay, I lost it again. Oh no. Okay, what if I right click on something? Nope, that does not help. Projector mode. Oh man, that's. Oh, I need to pull up my chat. Okay. Alex, did you delete a message? Yeah, I'm pretty sure one of those is Mrs. Wixom. Yeah, I think my new rule on suits is funerals, but I think if I were to go do what Colin's doing right now, I'd probably wear a suit. Oh my god, I need to get my mouse back without messing up the stream. Oh, I got an idea. Oh god. Give us some sound. Oh, back to private mode. Okay, they turned the cameras off. Man, I would hate if this goes right into like the afternoon adjournment. Oh no. Okay, I tried plugging in a wireless mouse and that I still can't see it. Oh, I got it back. Okay, cool. I mean, I would fast forward it, but... from the man store. Oh, okay, you could see my mouse too. Yeah, I've got like probably 10 different suits, and I've bought all of them at different weights. So depending on how large I am or small I am, some of them are gonna fit, some of them aren't. Oh, and if you're curious on the docket today, Alex did post it. It's pinned. If you remove the pin, I think it'll come back up. I think the pin comments randomly pop back up every once in a while. If not, I can always repin it. Oh, and Alex, by the way, you do have the mod power, but that doesn't mean you have to. You're stuck here. In case you feel that goes hand in hand, because this docket, I mean, this is gonna go all day, I think. Yeah, it'll still show up as a top chat, but if you click on those 3 dots, you can remove the pin. So sometimes people will remove the pin, but then later want it back. And sometimes if you go out of the chat and come back in, it'll be back there. Yeah. Well, I think right now my weight is at an all-time high, so I don't think any of my suits will fit. But I'm one of those types. I'm one of those guys that can gain weight, lose weight pretty quickly. It's just, oh man, I wish my wife would, if my wife was still fighting, here, I'll put myself back. If my wife was still fighting, then I just end up drinking a lot of water, eating chicken and rice, and then working out all day, every day, and then I get real small. But she's not fighting anymore, and we've got 2 kids, so it's real hard to be in the gym. I think I need to take my dogs on a walk. Oh man, this is a long adjournment. It's a lot easier to judge what's going on when they keep the cameras on, because if there's people sitting in the courtroom, then I know that everybody's not out to lunch. But as long as the stream is still on, I know they're putting a rolling. Let's see, how long has it been? It's usually about 2 hours. Wow, they're way past that. Maybe 3. I think the first block yesterday was 3 hours. 9. Let's see, what time is it? I'm guessing they'll probably go to probably about, well, it's 12:30 Eastern time, right? They're Eastern time, I think. Yeah, I stopped drinking a long time ago, but when I stopped drinking, I gained a lot of weight. But I got really, really small when I was drinking a lot. I know most people do the opposite. I was like sickly underweight by the time I stopped drinking. But if your suits are all too big, I know it's easier I know you can get them tailored to be smaller. I think tailored to make them larger is a little more difficult. I know some some places could tailor a suit to add more fabric to make some a little bit larger, but I think it's very marginal compared to going the opposite direction. All right, let's see. Man, this is a long break. I mean, I can't be sure that this isn't a lunch break. But the stream's still open. Yep. Oh, we might be back. I definitely drink beer, but I also drink a lot of tequila. Tequila was my buddy for a while. Tequila and Jack. Well, Colin looks a lot different now. Oh, wait, no. There's... I think my go-to, I drink I'd order 6 shots of tequila and then a Sunshine wheat beer. And that's pretty much how I set myself up when I would go to a restaurant or something. There are many, many reasons I don't drink anymore. Okay, let's make this bigger. I think it's gonna start again. People are sitting. It looks like it's about as full as it was earlier. Yeah, most of the hard stuff is pretty gross, but I just wanted to get to where I was going quicker. Oh, here we go.
Presiding.
You may be seated.
And she'll put what's on.
Yeah, let me do that. Okay, you're gonna try to find it. Yeah. Court recalls the case People versus Olin Thurman.
Allie Zend on behalf of the people, Your Honor. Assistant Public Defender Alexis Zerb on behalf of Mr. Thurman, who's approaching.
Colin Thurman.
Okay. Record should reflect prior to the system going down that we were having a bench conference. We concluded that bench conference. Fundamentally, the defendant was released to a particular address on a tether. That address is no longer available to him. He, in a nutshell, has a place which he can be released to. However, his release to that place would be in violation of his current bond conditions.
Yes, Your Honor.
Even if there's somebody there. Even if there's somebody there.
Your Honor, and just to further, he doesn't have any other location to go. It is my understanding that there'll always be some other adult present at that location. Even when the mother's children does go to work, her parents come to watch the children while she's at work. So if the court's concerned, we would ask for that bond condition to be modified to say no children except his own children. Like Your Honor is aware, they are his children, and the mother is present in court and is willing to.
Right. I understand, but with reference to the primary case, his release, his contact with his own children of that other relationship is only supervised. Right. So what, and I get why you may be asking, but what you're in effect asking the court to do is then to release him in the presence of kids unsupervised.
Well, Your Honor, it's my understanding that there will always be someone else at the home while the children are present.
Yes, and I get that. I'm saying it's not a structured supervision under sort of some type of monitoring. I get what you're saying. And I'm uncomfortable doing that. Young man, you don't have any other place that you could stay?
No, sir.
Okay, because here's the problem. I'm gonna do this in a way to try to be fair, because he's come here, he said what his circumstance is. He's been released, can't go back to the place that he was. Has tried to find, in good faith, I think, alternative living arrangements. And so I'm not faulting him for that. I just think that releasing him to that would be in violation of his current bond conditions. When I look at the bond conditions, the charges, I think that those bond conditions are appropriate. And so I'm not going to even modify or tweak those bond conditions in this case. I don't know enough to do that, first of all. But I also want to be fair to the defendant. So what I'm going to do, counsel, is I'm going to pass this to my 3 o'clock block.
Okay.
Give you an opportunity to try to find some other alternative in doing that. I think that's probably the best I'm going to do. I'm in effect, really what I'm doing is I'm resisting putting him back in. I'm going to give you a chance to kind of brainstorm, figure out something else before I'd have to come to that point. Okay.
Understood, Your Honor.
Okay. So we'll pass this to the 3 o'clock clock. My last one.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, I don't. Yeah.
That's fine.
Yeah. Okay. Court. Yeah, let's leave it out here. Court does call the case of the people versus Tamaran Jones recall.
And the original justice of people.
Sherilyn Foster Tucker on behalf of Mr. Jones.
Good morning, on Jones.
All right. I had given you another day and I had bond continue. At this point, I mean, I look back and the reason I didn't know about it is because typically if something like this happens and there's wanting to be a change in the bond and my staff let you know, Ms. McDuffie, we would need a motion on this to that so one could see exactly what it was. So at this point, I'm not going to deal with any bond violations. People want me to deal with it that way because he's got another case he's got to deal with. If they want me to deal with it that way, then they're going to have to file a motion. So I'm not going to do anything on it.
Okay. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Gregory Bell.
Howard Bell on behalf of Gregory Bell. Your Honor, thank you for recalling the matter. Mr. Bell is diabetic. He had to run to get something from the candy bar, from the vending machine because his blood sugar.
Okay, I'll call it up in the next block.
I appreciate
running
it.
behind you.
I understand. Thank you, Judge.
Gosh, yes. Ready. Here we go. I spend my life writing. You sure? In anticipation about what I'm going to go through right now, This is absolutely all your fault.
Oh. In anticipation.
In anticipation of it, I'm just letting you know.
Well, let me apologize in anticipation for this being my fault. I am sorry.
Court does call the case of the people versus Daniel Magoo.
Enter to the hearing on the appeal.
A second.
State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523. I have a couple things I'd like to point out about a couple of the matters here today.
What?
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement. Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that that charge is invalid.
That were going to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed, a motion for all dismissal on all these charges.
You're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion before this.
Ms. Lumby has let me know that all paper discovery has been sent to Mr. Magoo in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case to respond to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. Magoo, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So given that, that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
Yeah, I expected he would have them early next week, so if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then he'd have them well in advance, and I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, fleeing and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to immobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, yeah, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I do, I will. I have requested assistance given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented by?
I've called the prosecutor.
Mr. Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge Torsia, Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set, he's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bessard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
A response from the people regarding his bond.
People would ask the bond to continue, and he also failed to appear before Judge Slays. So
yes,
that warrant would also with respect to the other. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, with the court's appointment to Eastern Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the defender's office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still held, regardless of what the bond would. In this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
that's what I
would
Mr. Trotter said.
In any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in his bond in this case, that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
Well, and a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was not.
I understand.
I was not.
custody of.
I was dropped off at the hospital and they later tacked on
And
charges,
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
many of those, do not interrupt me. Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. The complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So.
I'm aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I did otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
All right, let's see if him and Colin recognize each other. Oh, they didn't show it.
Robert.
Okay, Mr. Magoo's at it again. He's complaining about due process, but he disappeared for a long, long time with a warrant, picked up a bunch of charges, broke every bond condition he had, and he's still a complainer. Oh yeah, and Sandra is definitely smoking right here. High five, Simpson. High five.
You swear to affirm the information contained in the search warrant affidavit. All right, fantastic. I will sign these and hand it right out. Okay, thank you, sir.
Smoky drinky.
And Mr. Priester?
I'm sorry too, Judge.
No, you know, I'm just gonna say sometimes there's just karma, man. All right. Folks, we are now way off track because of the delay and everything. I'm gonna give my staff a break. So I'm gonna give my staff a break. We will start up as soon as we possibly can. And the like, all right. Thank you. If they weren't counting.
All right.
Thank you, Judge.
I had a case of something when I was on the other side. I had a case of something.
They're still kind of bumping around in the background here, but probably a good time to make a transition. Here's what I'm going to do. I'm going to keep this stream open unless... You know what? I'm just going to keep this stream open. Yeah, you might get some dead air. But when I'll make sure the next streams... The next docket just stays on the same stream. That way I don't have to add the second stream. Although it's probably better for my channel if I do, but you know what, I'll think about it. Because then if I open a new stream, I could probably fix my chat. I don't know how long this break's gonna go, so if you see me stop this stream, let's do it like this. If you see me stop this stream, then I'm just going to just look for another one. I'll just reopen another one. But if I don't, you know what? I'm just going to stop the stream. Let's make it easy so I can fix the chat, and then we can see what's on the second half of the docket. Cool. All right. See you guys very, 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 very soon. I appreciate you hanging out. Please hit the like button on your way out if you are willing to do so. Also, in the description of the video, you can vote today for Toddler of the Year. If you drop a vote for Maverick, I truly appreciate it. And just come through everything else in the description. He said he's got a 3 o'clock block, so he'll probably do lunch before that. Yeah, I'm thinking it's lunch too. The fact that people are checking in right now is my only concern, but I think we all have some time. I think this is a break for all of us. So, yeah, I'm going to stop the stream. I'll keep an eye on it. I'll open another one when the next one starts. Hopefully I got enough time to take a shower, take the dogs out, eat some food. Hopefully you guys have this time to do the same. So, please hit the like button on your way out, and I will see you super... let's see, he said 3 o'clock, so it's 1 o'clock their time. And yeah, okay, cool. All right, guys. Well, I appreciate it. I just gotta figure out how to. Man, it's still playing though. Yeah, go bang on the drums. I'm gonna look for some